resources, money, equipment, or credit to the table, and it'll deal with all elements of acquiring, owning, operating, maintaining, fixing, and ultimately selling that property. So those joint venture contracts can be fairly unique to the actual deal. It will depend on, to some degree, even the particular property, what folks are doing. But without this agreement, without a joint venture contract, you get stuck with, Your Honor, he said, she said. But I told the guy I was doing this, and he said it was okay. You can imagine what the court does with that. It's difficult at best. So joint venture contracts are important to outline what if somebody dies, what if we can't get along, what if we want to sell the place. Just like shareholder agreements, just like partnership agreements, they're all similar in that regard. If you're going to both go on title, if we've got multiple owners of land, we can have two choices, tenancy in common or joint tenancy. So if Bob and Tom are on title, or tenancy in common, which is presumed in Alberta. So if the title just says Bob and Tom and nothing more, it's tenancy in common. There's no right of survivorship, meaning if I die, my interest goes through my estate, through my will or lack of will. Bob does not get it. My wife does, for example, because that's who I left it to. So that's very important to know. It goes through my estate, therefore it's subject to my creditors and my taxes, by the way. But my wife gets the residual, and it's more appropriate in a commercial setting. I love Bob like a brother, but I want my wife to get stuff when I die, not him. The other choice, joint tenancy, does have a right of survivorship. If I die, then Bob instantly gets my share. It becomes his property by operation of law at my death. It does not go through my estate. It does not go to my wife. It does not go to my taxes, my creditors. It goes to Bob automatically. And that's usually desirable in a personal setting. So for example, if myself and my wife are on title, we may wish to be joint tenants. So if I die, the creditors can't touch it. My wife just gets the house automatically. All she has to do is produce a death certificate, and the registrar will put it in her name. Co-ownership for trusts. Trusts is a unique relationship that comes up a lot in real estate investing, and a lot of people quote them and say trusts are great, we should create a trust. Trusts are very specialized tools, but they're a relationship between the parties where some creator of the trust, the grantor or settler of the trust, say me, will give some property, a house, to Bob the trustee for Sam the beneficiary. So I've separated the legal ownership from the beneficial or use, and I've given it to two different people. In the example, when I gave the house to Bob the trustee, Bob is on title. Bob is the legal owner of the house. He's on the mortgage. He's responsible for taxes. Bob is sued if there's any problem with the land. But Bob doesn't get to use the property. He only owns it under the terms of the trust for the benefit of Sam, the beneficiary. Sam can party like it's 1999, and so long as the trust permits it, he can use it at his pleasure. The trust may be limited that he can only use it on weekends.